Welcome to the deep dive. Today we are really zeroing in on a single high-stakes court session, the October 10th hearing.
That's right. It concerns the entry of temporary orders in that ongoing legal conflict, Aguirre v. Espina.
And this hearing, it wasn't even supposed to be about evidence or arguments, was it? It was just scheduled to sort of formalize decisions made verbally almost a month before.
Correct. September 11th was the verbal ruling. October 10th was meant to be purely administrative, signing the papers.
But instead, it immediately descended into this legal brawl over technical due process.
Yeah.
Very technical.
Our mission in this deep dive is to analyze how these really fundamental concepts of procedural justice, things like proper notice, and the actual duties of a judge were tested. Under fire, really.
Right. And we're looking at the detailed transcript from that October 10th hearing itself, plus this pretty explosive legal challenge filed right after with the appellate court.
Yeah, that filing shows the realtor's strategy, basically turning these procedural setbacks into evidence. Evidence arguing systemic bias.
That's right. So for you, the learner, this is, it's more than just a case study in family law. It feels like a masterclass in what's being called procedural lawfare. We're going to unpack exactly how this, perfect storm of late drafts, a judge seemingly not ruling, and some really aggressive scheduling tactics can create a legal landscape, one that seems designed to just strip a litigant of their ability to respond effectively.
Yeah, we need to understand not just what happened, but critically, how these maneuvers function, how they're used as, weapons in the legal fight.
Okay, let's unpack this core issue first.
Right.
Lack of proper notice. So the hearing on October 10th, it's set to sign temporary orders from that verbal ruling back on September 11th.
Right. Straightforward enough, you'd think.
But like you said, before anyone could even get to the substance of the orders, the whole thing just devolved into a fight over which version, which specific draft was actually, validly before the court.
And this all comes down to Texas Rule of Civil Procedure 21A, TRCP 21A.
Ah, yes, the notice rule. What does that typically require?
Basically, it requires a party to serve documents on the other side with 3 business days' notice before a hearing. It's fundamental. You need time to review and respond.
Okay, so opposing counsel, Morgan Hibner, she tried to use this rule, right? She claimed she sent a draft way back on October 2nd.
Exactly. She argued, look, the hearing's on the 10th. I sent this on the 2nd. That's 8 days. Plenty of notice. That was her initial position.
But the relator, Mr. Marcano, he pushed back hard on that. He laid out a very precise timeline of changes.
Yeah, he wasn't really disputing the October 2nd date itself. His point was the draft you're trying to get signed today, October 10th, is not the document you gave notice for on the 2nd.
Because it had been changed?
Right. He pointed out different drafts were sent on October 7th, specifically after 10 a.m., which can matter for timing rules, and then incredibly modified and sent again on October 9th.
October 9th. That's literally the afternoon before the hearing.
Precisely, the afternoon before.
Yeah.
So let's just pause on that timeline because it's so critical for due process. If a document is changed, especially in any substantive way, the notice clock basically restarts. You can't just say, I gave notice for a draft back then. It has to be notice for this draft.
Well, the version served on October 9th. Well, that clearly violates the 3-day rule for an October 10th hearing, no question.
Absolutely. And then came what seems like a really crucial moment on the record. Opposing counsel, Morgan Hibner, she actually admitted she had modified that initial October 2nd draft.
She admitted it. What did she say?
She said she did it to add a small paragraph at the bottom. And she claimed this was done to address issues the relator himself had raised.
So she's trying to frame it as helpful almost, but admitting the modification, that kind of gives the game away, doesn't it?
It really does. It seems to validate the realtor's entire objection. Because, like you said, it doesn't matter if it's a small paragraph or half the document. The fact is the document was changed, and the relator immediately seized on this. He stated clearly, look, any modification, big or small, means the draft before the court today is structurally not the document originally noticed back on the 2nd.
Because due process means you get notice of the specific thing the court is going to act on.
Exactly. If the instrument changes, that original notice is, it's void. It's nullified for the new version. So her admission of modification, it basically conceded the point legally. It validated the improper notice objection.
And this is where it gets maybe a bit more pointed. The relator didn't just point out the rule, he pointed back at the judge himself, right?
Yes, he immediately brought up the judge's own prior ruling from September 11th. He reminded the court that back then, the judge had very strictly enforced this exact notice rule against the relator.
Using the phrase due process works both ways.
That exact phrase.
Yep.
The relator quoted it back to the court. This becomes the absolute centerpiece of the procedural argument. It's about equal application of the law.
So the argument is essentially, you held me to this standard last month, Judge. Now you have to hold the other side to the exact same standard.
Precisely. If the judge were to now say, oh, this modification is minor, it doesn't count, he'd be setting up a clear double standard, applying the rules strictly against one party, but loosely for the other.
Which could look like bias.
That's the implication. The realtor laid it out plainly. The order that she's bringing for consideration today is not the same order that she submitted on the second. It's not the same. It seemed like a clear procedural path to just set aside that draft.
Okay, so the realtor makes this clear objection. I object because lack of proper notice. It's on the record, it's timely, it seems legally valid based on the admission. What happens next is what the later filings called a structural failure of the judicial process.
Yes, because the court has a specific job to do at that moment.
Which is?
To rule on the objection. And this is where we need to be really clear about different judicial actions. Sometimes a judge has discretion, like deciding if evidence is relevant, but ruling on a timely, properly made objection like this one, that's generally considered a non-discretionary duty. Some call it a ministerial duty.
Meaning not optional.
Meaning not optional?
Yeah.
The judge is legally required, essentially, to make a ruling, to say either sustained, meaning the objection is correct, or overruled, meaning it's not. It's a fundamental step in the process. You have to rule.
But Judge Oscar Telfair III, he didn't rule.
According to the record and the subsequent filings, no. He didn't say sustained. He didn't say overruled. He apparently just ignored the objection entirely.
Ignored it. And did what instead?
He skipped right over the procedural point, which, if sustained, would have stopped discussion of that draft right there. And instead, he asked the realtor, well, what's the problem with the draft, Mr. Marcano?
Wow, so basically forcing the realtor to argue the substance, the details inside the draft.
Exactly. Forcing him to argue the merits of a document that, based on the objection, shouldn't have even been on the table procedurally due to lack of notice.
That seems problematic.
It's critical. This act of, well, not acting, it violates a pretty fundamental right. And importantly, when a judge fails to perform a non-discretionary duty like this, it's not just a reversible error on appeal later.
No.
No, it could be grounds for immediate appellate intervention through something called a writ of mandamus. The higher court can basically order the lower court judge to do the thing they were legally required to do. In this case, rule on the objection.
So if the judge had just overruled the objection, saying, no, I think the notice was fine, the realtor could maybe appeal that ruling later after a final order?
Yes, that would be the normal process. He'd preserve the error for appeal.
But by simply not ruling, by ignoring it.
The judge essentially prevents the creation of a clear record on that specific procedural point.
Yeah.
There's no ruling, no sustained or overruled to actually challenge later on. It leaves the litigant kind of stuck.
So the harm is like twofold. It messes up the hearing right then and there.
Right, by making them argue about a potentially improperly noticed document.
And it potentially blocks the path to appealing that specific procedural violation later.
Precisely. The subsequent legal filings argue exactly that. This silence wasn't just an oversight. It was an abandonment of judicial duty, a structural failure of the whole process.
And this wasn't the only time the realtor felt silenced in this hearing, was it?
No. Later on, when the discussion turned to rescheduling, the realtor tried to object again. Object to the very quick rescheduling and the ongoing delays.
Then what happened then?
According to his filings, he was cut off. He used the phrase, literally begged the judge to be heard, and was shot down the 2 times he tried to object.
So it wasn't just a failure to rule on the notice objection, but maybe an active effort to stop him from even making other objections on the record.
That's certainly the picture painted in the filings sent to the appellate court. It suggests a pattern, moving beyond just a single error, potentially indicating a more sustained effort to deny him procedural recourse.
If you can't even get your objections heard and recorded, the whole idea of a fair process starts to crumble, doesn't it?
It really does. It undermines the legitimacy of the proceedings.
Okay, so the judge bypasses the notice objection and wants to talk about the draft itself. Why was the realtor fighting so hard about the notice? Because the changes weren't just like fixing typos, right?
No, absolutely not. The filings detail what the realtor called material, very serious changes. These went far beyond the scope of what was actually ruled on verbally back in September.
What were the big ones?
Probably the most critical change was about the duration of the temporary orders. The verbal ruling on September 11th was very specific, a fixed 60-day period.
60 days. Okay, that sounds temporary. Why is a fixed period like that significant?
Well, a short fixed term provides some certainty during the interim period of a divorce. It gives the person subject to the order a clear date for review. And crucially, once that fixed term order is signed, it allows for an immediate appeal.
Okay, so the verbal ruling was 60 days. What did opposing counsel's draft say?
The draft changed it to an indefinite term. The language was something like until final decree of divorce or until a further order of the court.
Whoa, that's completely different.
It completely changes the game. It turns what was supposed to be a temporary short-term suspension of parental rights into something that could potentially last for years, right up until the final divorce.
And if the judge had signed that version,
The realtor would be locked into this indefinite restriction, losing the benefit of that original 60-day limit, and potentially facing a much longer, harder road to get it reviewed or appealed.
were there other substantive changes besides the duration, things that weren't in the original ruling?
Yes, the second major issue highlighted was what the realtor called the fabrication of financial obligations. The draft apparently introduced a series of financial obligations that were never rendered verbally.
So just adding new financial burdens that the judge never actually ordered?
That's the allegation. Inserted unilaterally by opposing counsel into the draft order. When you combine that with the change in duration, it really elevates the issue beyond just inaccurate paperwork. The realtor framed it as a fraudulent attempt to impose entirely new penalties after the fact.
And speaking of framing things, let's talk about the language opposing counsel, Morgan Hibner, used when she was defending these changes. She said she made edits based on what the realtor took issue with. But then she added that phrase.
Ah, yes, from what I could decipher from his filings.
Yeah, that phrasing seems loaded.
It does. It's a tactic some might call narrative seeding, or even poisoning the well. The realtor certainly saw it that way. He argued it was calculated to imply that he is the problem, that he's crazy or his filings are just impossible to understand.
So it kind of subtly shifts the blame, suggesting any confusion or delays because the realtor isn't being clear.
Exactly. It tries to create a narrative that justifies the other side's unilateral changes and the court's potential confusion. It protects them from scrutiny by painting the realtor as inherently difficult or unclear, even if, as the realtor argued, his filings were actually concise and direct.
Okay, so substantive changes, questionable rhetoric.
Yeah.
Then the judge, having skipped the notice objection, pivots immediately to rescheduling the hearing.
Right. And this is where we see that alleged TTP, the tactic, technique, procedure pop up again. The one the realtor claims is used repeatedly in this court.
What was the initial suggestion for rescheduling?
The judge first suggested the following Monday, then quickly pivoted to Tuesday morning at 9:20 a.m.
Tuesday morning, after a Thursday hearing.
Yes, which would mean, again, only one full business day Friday between the hearings.
And that's the trap, right? The TTP mechanism.
That's exactly it, according to the realtor's analysis. It creates this perpetual procedural loop. Because TRCP 21A requires that 3 days notice for filings, scheduling hearings this close together basically guarantees the other side cannot file any meaningful objection or response or counter motion with proper notice.
You're structurally blocked from following the rules because the schedule itself prevents it.
Correct. You're denied due process by the calendar, forced into just reacting constantly without adequate time to prepare or formally object according to the rule.
And the realtor tried to object to this rescheduling tactic.
Yes. As we mentioned, he tried to object to the speed and the further delays, but said he was cut off.
So what date did they finally land on?
After some back and forth, apparently due to counsel's availability conflicts on Monday and Wednesday, they eventually settled on Thursday, October 16th at 9 a.m.
So that gave a few more days than the initial Tuesday suggestion.
It did buy a little more time, yes. But the realtor argued that the attempt to schedule it so quickly, the fact the court kept suggesting dates that clearly violated the notice rules, still demonstrated a kind of calculated disregard for procedural fairness.
The scheduling calendar itself used as a weapon.
That's the argument. It becomes the first line of attack in this kind of lawfare.
So the hearing ends, a new date is set, but the realtor doesn't just wait. What was the immediate countermove?
An immediate, very strategic countermove. On that same day, October 10th, a first supplemental petition for writ of mandamus was filed with the Court of Appeals.
Using the events of that very morning's hearing as fresh evidence.
Exactly. Using the transcript or the record of what just happened as new dispositive proof supporting the need for appellate intervention.
Okay, remind us again, what exactly is a writ of mandamus? What does it ask the higher court to do?
It's considered an extraordinary legal remedy. You're basically asking the higher court to step in and order a lower court judge to do one of two things. Either perform a specific duty they are legally required to do but haven't, a ministerial or non-discretionary duty.
Like ruling on that notice objection.
Precisely. Or to order the judge to undo something they did that was clearly outside their authority or a violation of fundamental rights.
And the October 10th hearing provided the ammunition for this.
It provided crucial evidence, yes.
Yeah.
Evidence to argue that the judge failed that non-discretionary duty to rule, and importantly, that the events showed a clear pattern of bias that warranted immediate appellate review.
What was the single most powerful argument in that supplemental filing? You mentioned it earlier.
It really hammered home the unequal application of Rule 21, the notice rule.
The due process works both ways. Contradiction.
Exactly. The filing framed the judge's actions, strictly enforcing the rule against the relator on September 11th, then completely ignoring the identical objection from the relator against opposing counsel on October 10th, as the very definition of arbitrary and biased judicial conduct.
So arguing it wasn't just a mistake, but intentional unequal treatment.
Yes. It argued this goes beyond simple judicial error, which you'd normally appeal later. This unequal treatment, they argued, is structural evidence of bias, justifying the extraordinary step of mandamus now.
The filing also attacked some of the specific things inserted into that controversial draft order, didn't it? Like the part about a psychological evaluation.
Yes. The draft included language saying the court would review relator's request for psychological evaluation at some future date.
Why was that specific provision flagged as alarming in the mandamus petition?
The relator argued that this language, which opposing counsel apparently added proactively wasn't something ordered by the judge, represented an unconstitutional delegation of core judicial authority.
What does that mean, delegation of authority?
It means the power to review, evaluate, and potentially order something like a psych eval rests with the judge. That power generally can't just be handed off to the opposing party to bring up whenever they want, or left hanging indefinitely without a clear judicial framework.
So if the judge signed the order with that language in it...
The argument is he'd essentially be letting opposing counsel dictate future procedural steps, turning the court into a kind of rubber stamp for their agenda, rather than exercising independent judicial authority. It undermines the whole structure.
And then there was that even more overtly aggressive language about international abduction.
Yes. The supplement highlighted counsel inserting highly prejudicial language threatening relator with severe penalties for international abduction.
Which was never even mentioned in the September 11th ruling.
Never mentioned, never ordered, apparently no basis for it in the verbal ruling whatsoever.
So why put it in? What's the point?
The relator argued its sole purpose was malicious to create a false and damaging narrative. It's classic narrative poisoning again.
How so?
By inserting this incredibly serious federal crime-level accusation into a state court document, even if it's never proven or formally adjudicated there, opposing counsel creates a piece of paper, a prejudicial document they could potentially wave around in other contexts, maybe federal court, maybe international proceedings, to damage the relator's reputation and paint him as dangerous.
Wow. Regardless of the truth, just getting it written down somewhere official.
Exactly. It speaks to an intent, the relator argued, that goes beyond the immediate case, aiming for broader legal warfare and reputational harm.
So given all this, the refusal to rule, the unequal standards, these fabricated provisions, what did the mandamus filing ask the appellate court to do urgently?
It concluded with an emergency request for a stay.
Meaning? Asking
the appellate court to immediately halt the newly scheduled October 16th hearing in the lower court. The argument was direct. The October 10th hearing shows such a clear pattern of procedural abuse and bias that forcing the relator back into that same environment would itself be a violation of his due process rights.
Basically, stop the proceedings below until you, the higher court, can review this pattern of misconduct.
Precisely. Stop the clock before more potential harm is done.
Now, to really get the full picture of what was happening around October 10th, we need to add one more layer of context. Information the relator apparently received just the day before, on October 9th.
Yes, he documented receiving intelligence, allegedly from an informant, about ACME Laws, the opposing counsel's firm, their tactical plans.
And what was the alleged plan?
The informant supposedly stated that ACME law's primary goal was to get a contempt of court charge filed against the relator.
Contempt. For what?
The alleged basis was the relator's actions in exposing the alleged fraud by counsel to the appellate court. Basically, contempt for reporting their own alleged misconduct.
Wait, so the plan was to charge him with contempt for blowing the whistle?
That's how the relator interpreted it and documented it. He immediately called it a perversion of the legal system.
That seems like a strong reaction, but understandable if that was the plan.
Well, his reasoning was that a person has a civic duty, arguably, to report serious accusations like fraud upon the court, under oath, to the appropriate judicial body, like the Court of Appeals.
Okay.
If the lower court's response is not to investigate the serious fraud accusation, but instead to prioritize punishing the accuser with contempt potentially leading to fines or even jail time.
It sends a chilling message. Don't report misconduct or you'll be the one punished.
Exactly. The relator's filing actually drew a parallel, suggesting this tactic mirrors what happens in authoritarian regimes where whistleblowers or accusers are silenced to protect the powerful or maintain the status quo. It raises a very uncomfortable question about whether legal procedures designed for justice can be twisted into tools of suppression.
So silencing or neutralizing the relator was one goal. Was there another alleged purpose to this contempt strategy?
Yes, a critical secondary goal: distraction and delay.
How does a contempt charge create delay?
It creates conflict, it creates an impasse, and this ties directly back to that issue of the unsigned temporary orders from September 11th.
Ah, the orders that were verbally made but never actually signed, putting the relator in that limbo state.
Exactly. That unconstitutional legal limbo, as he called it. Remember, the hearing on October 10th was 29 days after the verbal ruling, and the order still wasn't signed. Why the delay?
The contempt charge provides an excuse.
It provides a perfect narrative. Opposing counsel and potentially the court could say, well, we can't finalize these orders right now because we have this pressing issue of the relator's contemptuous behavior to deal with first.
So it shifts the blame for the delay onto the relator himself.
Precisely. The relator said the goal was to put the blame of the delay, on me. Meanwhile, he's the one who actually wants the order signed.
Why does he want it signed if it restricts his rights?
Because under Texas law, generally only signed orders are appealable. He needs that signed order even though it's harmful so he can finally challenge it in the appellate court. The delay keeps his rights suspended and blocks his path to appeal.
It's a catch-22 created by the delay.
A procedural trap maintained by inaction and potentially manufactured conflict, like a contempt charge. It's a stark illustration of how lawfare can operate, using the rules, the calendar, judicial silence, everything to paralyze the process and prevent review. #outro. So what we've really dissected today, focusing just on that October 10th hearing transcript and the immediate filings that followed, is, well, it's a chillingly detailed look at high-stakes procedural lawfare in action.
Yeah, the record-keeping seems meticulous here.
It does, and it aims to expose what the filer claims are systematic violations of fundamental rights. Things like the refusal to perform that basic judicial duty of ruling on an objection.
The unequal enforcement of notice rules, strict for one side, ignored for the other.
Exactly. And this constant threat, this industrialized use of the court calendar as a trap to keep the relator from ever getting his case properly reviewed by a higher court.
So for you, the learner, this deep dive really highlights how seemingly mundane legal concepts like proper notice can become incredibly potent weapons when procedures get twisted or weaponized.
Yep.
I think the key takeaway here is recognizing that judicial legitimacy really hangs on fairness and equal application. When a judge doesn't say sustained or overruled on a key objection, that silence isn't necessarily neutral.
No, as argued here, it can be a functional act, an act of essentially judicial abandonment that's designed, intentionally or not, to block appellate review.
So pay attention to the basics, the calendar, the rulings or lack thereof on procedural points. They are often the first signs, the structural levers of this kind of attack.
That's a great point. And the relator's documentation of this specific TTP, the tactic of scheduling hearings too close together to allow for proper notice, he argues it leaves a distinct, measurable footprint in court records.
Which leads us to our final provocative thought for you to mull over. If this TTP leaves a footprint, could investigators, or maybe AI analysis tools, apply this filter systematically? Could they search across court records, across jurisdictions, looking specifically for this pattern? Judges repeatedly scheduling back-to-back hearings that structurally violate notice rules like TRCP 21A.
You mean use that pattern as a kind of industrial blueprint?
Exactly. Could that footprint be the key to detecting organized lawfare networks at scale? Could it help identify patterns of procedural abuse and the specific judges or firms potentially involved, allowing us to see the bigger picture?
That is a fascinating and potentially powerful idea for future investigation, using the procedure itself as the detection mechanism.
Something to think about. We'll see you for the next deep dive.